Investment Law 2025, a breakthrough in offshore opening, a new horizon for Vietnamese investors. In the context of rapid globalization, outbound expansion by Vietnamese investors through offshore models is no longer just a trend, it has become an essential strategy. Notably, with the latest updates from the Investment Law 2025 and Decree No. 103/2026/NDCP, the gateway to outbound investment is widening, becoming simpler, more transparent, and more legally compliant than ever before. 1. Offshore. Beyond just tax havens, offshore structures are no longer merely about tax avoidance, as commonly perceived. Today, offshore models offer substantial strategic value, global market access, tapping into international markets, USA, Singapore, Hong Kong, etc. Global corporate structure optimization, enhancing corporate efficiency, foreign capital attraction, facilitating international fundraising, asset protection, cash flow flexibility, securing wealth and capital movement. Common offshore models, Singapore companies, highly reputable and optimal for corporate bank account opening, Hong Kong. Companies, Asia's premier financial hub, US companies, Delaware/Wyoming highly flexible legal frameworks, BVI companies, ideal for holding company structures. 2. Regulatory breakthroughs in the Investment Law 2025. One of the most pivotal changes introduced is, outbound investment projects with a capital value of under VND 7 billion that do not fall into conditional business sectors do not require an outbound investment registration certificate. What this means in practice: elimination of complex, licensing barriers, significantly shortened time to market for offshore setups, reduced initial regulatory compliance costs, instead, investors only need to declare project information on the National Investment Information System, receive an automated dossier code, register foreign exchange transactions in accordance with the regulations of the State Bank of Vietnam, SBV. 3. Transparency. The key to international cash flows. The core intent of the new policy is not to restrict, but rather to encourage investors to take a transparent path to legitimize their global cash flows. When the proper process is followed, outbound remittances are fully recognized and protected by law. Inbound repatriated profits can be officially recorded as dividends or capital investment income, thereby qualifying for optimized tax rates under current regulations. Conversely, non-declared investments face severe consequences. Remittances may be flagged as unexplained funds or wealth. High risks regarding tax compliance, foreign exchange violations, and international financial tracing/AML audits. 4. A strategic direction for offshore models in 2026. This legislative shift establishes a clear direction. Offshore is no longer a detour, it is the main highway, provided it is executed correctly. Investors should combine offshore setups with legal outbound investment declarations, establish clear ownership structures, individual versus corporate parent company, manage cash flows through transparent, regulated banking systems. 5. Unprecedented opportunities for Vietnamese investors. Under this new legal framework, for the first time, small-scale investors, under VND 7 billion, can legally enter the global playground. No complex corporate structures required, no lengthy licensing processes needed. This marks a strategic paradigm shift, from circumventing the law to move fast, to complying with the law to go far. 6. Conclusion. The Investment Law 2025 and Decree No. 103/2026/NDCP have established a progressive legal corridor by simplifying procedures, enhancing transparency, and legitimizing cross-border cash flows. Offshore is no longer a regulatory gray area. It has evolved into a mainstream investment strategy. The question is no longer, should we go offshore? The question is, how do we structure our offshore entity to be both highly efficient and legally secure?